All right, let's go ahead and get started. My name is Chinachun and I'm with NACB and the Consultants Training Institute. Before we get started with today's webcast, I want to go over a few housekeeping items. First, to obtain CP credit, you must answer all the poll questions that pop up on your screen during the webcast today. If you have an ABW subscription, CP certificates will be available in your NACBA.com portal within 7 to 10 business days. If you have any questions during today's webcast, please use the Q&A feature as also be directed to the presenter. If you have any technical questions or questions about any CBA, please feel free to use the chat feature in Zoom, as those will be directed to me. Again, with ABW and ABW International, we try to keep you updated on the upcoming trends or hot topics in the industry. Within the 2 hours that we have, we don't have enough time to cover all of the information. So we do have some links to some additional resources where you can actually view and read about some of the upcoming topics and hot topics in the industry. And with that, I'm going to turn the time over to Alina, who will get us started with the webcast today.
Thank you, Shanda, and thank you everyone for joining us today during this monthly show. Today we are going to have Janae. She's going to be talking about industry updates. We also have Roberto Castro, so we have a little bit of change in our normal itinerary, but we're going to have Roberto Castro after Janae talking with our judges, and they are going to be discussing the perspectives from the bench with the American judges, and they are going to talk about watch your words. And after that, I'm going to be interviewing Arli Cornejal. You know her. She's been with us, and we are going to be talking about Partners Launch and Learn, the finance programs on her organization that you can help other small business owners. And we're going to have Stephen Y. He's going to be talking to Achille, and they're going to be talking about the impact of tariffs on small businesses, valuation, the risk, the realities, and best practices. And we're going to have, this is the month that we have Michael Mulder talking about the federal and state case law summaries, and he's going to be talking about Harnack. And at the end, we're going to have Ed Mofrad. He's going to be interviewing Austin McNair, and they are going to be talking about understanding how to build visibility for your business in 2026. So right now, I'm going to leave you with Janae. Janae is one of our correspondents. She's with us every month. And it's so great to have you with us, Janae. So you can take it from here.
Great. Thanks, Alina. It is great to be here. We've got the industry headlines for this month, and we're going to go through some articles, such as an article that appeared in the European Business Valuation magazine about valuation of intangible assets and an integrated relief from royalty method and Monte Carlo simulation approach. This appeared in the summer edition. There are 4 editions of that magazine, the EBBM, that come out every year. We're also going to talk about net working capital, which appeared in the Quick Read, which was written by Greg Clark, the One Big Beautiful Bill Act and its impacts on valuation by Trish Garthoffner, the Unimpeachable Rebuttal 2.0 by Zach Myers from the Quick Read on September 17th. From the BV Wire, we've got PE firms turning to more outside valuation experts, as well as Kroll lowers the recommended US ERP to 5%. The RADA tip of the week, understand its content and scope. These are all BV Wire articles. So the takeaways for this month from this segment are to consider adding Monte Carlo analysis to a relief from royalty methodology for your intangible assets. Net working capital requires more analysis than just current assets minus current liabilities for valuation purposes. The OBBBA or HR1 requires changes to valuation analysis models, but don't freak out. AI can be a good tool, or can be a tool for good or for evil in rebuttals. PE firms are increasingly engaging outside valuation experts. Kroll has lowered its recommended ERP, and RADA is a closed system. So some takeaways. We'll get a little bit more into the meat, but again, this is an overview level of some of these issues, and I encourage you to go back in, read the articles, and familiarize yourself if this is something that sounds interesting to you. I'll provide links at the back for anything that is in the public domain, anything that's free to download, and at least give you the publication so that you can track down anything that may be a pay for subscription type of service. Okay. So the valuation of intangible assets. This was a very interesting article. It presents maybe an innovative approach to intangible asset valuations by combining the relief from royalty method with Monte Carlo simulation to address some of these uncertainties in the valuation process. The author demonstrates how the integrated methodology can enhance strategic valuation decision making when looking at patents, trademarks, and other intangible assets or intellectual property that lack a robust market data, financial data. The author acknowledges that the relief from royalty method, or his premise is that the relief from royalty method requires several difficult to make assumptions, especially due to the lack of data. The Monte Carlo simulations are proposed as a tool to improve the relief from royalty method. So, it sounds like a lot of big words, a lot of complicated modeling, but when you really break it down, it's not that complicated of an idea conceptually. So the article does talk about the epistemic information on these epistemic problems, which I admit I had to go to my dictionary and look it up, but it's talking about cognitive or knowledge-based. Epistemic refers to cognitive or knowledge. So these are uncertainties that arise due to lack of data or information. So the proposed methodology, this combination, attempts to address some of those issues by quantitative means using these 3 steps. So the first is moving beyond a single point estimate to capture reality. Instead of relying on one assumed royalty rate, where do we get that from? We say, oh, maybe 25%. We know that we've got to do better than that. There's some databases and some things, but looking at instead of one assumed royalty rate, one growth rate, and one discount rate, it uses probability distributions to model all 3 key inputs simultaneously. And it says, this addresses what we all know, that there's not just one right answer when valuing intangibles with this limited market data. So the simulations run, thousands or tens of thousands of scenarios to show ranges of possible values and their likelihood, which can be helpful, right? It's a practical way to use expert judgment when data is scarce, when you can't find comparable royalty rates or reliable financial data. The method is giving you at least a structured way to estimate best case, worst case, most likely scenarios for each of the assumptions, and it gives you a formal process. Now, again, remember, don't confuse these kinds of simulations or lots of numbers and data for accuracy, right? This false sense of, or this sense of precision that we assume means accuracy. But this is good. You can run a lot of simulations. I think it'd be very interesting. I will say that the article it's formula laden, which you might find overwhelming, or you might find very helpful as it walks you step by step through the calculations and the methodology. It's about 4 pages, so it really is not terribly long. Again, on this slide, right? It's focused on German technology patents. So that's the test case in the article. But I think and then this is an international valuation magazine, but I'm not sure why the methodology would not apply domestically to US patents and intellectual property, things that you're looking at, the relief from royalty method. I am looking forward to exploring more articles actually from this magazine and kind of giving us a slightly different perspective than what we're used to, and looking at some data that we may not typically find in some of our US databases. So I think it's very interesting, and I'm looking forward to kind of going through some of those articles a little bit more. There was also, if you're interested, in an article on AI and machine learning in that 3rd summer edition of the EBVM. Okay. So this article by Greg Clark on net working capital starts out making several distinctions among various balance sheet accounts, and moves beyond the accounting definition of working capital into looking at the rationale for analyzing and utilizing net working capital. And it kind of throws a lot of different takes of working capital, net working capital. Like, okay, you could look at it this way, and okay, what about this? And I think the point, the helpfulness of that is saying, okay, well, what are we trying to do? What is the purpose of this valuation? Why are we looking at net working capital? Why does that matter? So it discusses why cash would be excluded from net working capital as well as enterprise value. It does discuss briefly handling cash as an add back, as far as only adding back excess cash versus adding back all cash, and recommends, maybe adding back all cash. Of course, it's always a debate in our profession, but there are also a handy list of considerations when you are looking at net working capital for your valuations. So take a look at that article from the Quick Read Buzz. This article from Trish explores how HR1 reshapes the tax landscape in ways that directly alter the assumptions embedded in our business valuations. The legislation introduces changes ranging from accelerated expensing to revamped QSBS, qualified small business stock rules, which shifts the numerator, the cash flows, as well as the denominator, your risk. The accelerated cash flows, you may just need to look at the forecasts or your projections and make sure that those make sense and that they're maybe taking into account the accelerated depreciation. That if you accelerate, the cash flows, or you move up the timing of the cash flows received, that has an impact on your valuation. So make sure that you're considering this, especially for asset-intensive businesses. The article, advocates modeling multiple scenarios for uncertainty regarding the potential sunsets to provisions after 2028 in the OBBBA. So that may be something that you want to look at too. The QSBS may be more of a limited applicability for startups or for other types of business. It may be a little bit outside of what we are traditionally valuing in our practices with long-standing, Main Street businesses that aren't looking for outside financing, but still be aware of it. And then also consider the long-term macro risks for your valuation and how that's going to look. Now, she did mention that this is not, this wholesale giant, change to get worked up about. Okay, just there are some changes. Be aware of a few of the changes. Go check out our article and see kind of what some of those are. There have been some other articles written. I think there was one in Mercer recently, the Value Matters, that you might check out. It's a little bit longer if that's something that you are concerned with. Okay, the unimpeachable rebuttal 2.0. The age of rebuttal is being crafted by AI, or largely by AI, has reached us in the valuation world. Myers relays getting voluminous critiques and rebuttals that are mostly fluff and of little substance. And he says he has also been incorporating AI checks on his reports to find things like typos or get brutally honest feedback, as well as to imitate aggressive cross-examination or identify areas of confusion for triers of fact. So he's using it for deposition prep, trial prep, to check his report. He's always using it as a tool, not as a substitute. He talks also about, which I found very interesting, turning AI on itself in these avalanche-style rebuttals. So these huge rebuttals are, hundreds of pages and have, 600 points of, critique. And so he was using AI to categorize and identify criticism, the criticisms that have merit versus just the flimsy attacks. So that was kind of fun, kind of interesting. He gets these AI critiques, these AI rebuttals, so he has AI review the AI rebuttal. Anyway. There is, of course, a lot of food for thought as well as practical advice to incorporate into your practice. I recommend reading this article by Zach. Besides, he's just an entertaining writer. So PE firms turning to more outside valuation experts. The article cites resource constraints, complexity, best practices, auditor demands, push for greater transparency and independence and external validation, as well as more competition, as these components that are leading to the shift to independent valuations. Funds and fundraising are seeing independent valuations as a competitive advantage, and the doors may be open for you to build strategic relationships with PE firms. So, interesting quick article to look at. Kroll recommended or lowered its recommended ERP from 5.5% to 5%. This was amid boos and jeers from the NACVA National Conference audience. So be aware of that for your valuations. Also, we've been talking a lot about closed systems and AI tools and data security in the ADW and everywhere. And so I think it's important to know, if that was interesting, that RADA is a closed system tool. So your data, the data that you're receiving is only from BVR and nothing's going outside. So I thought it was interesting. There's only vetted content. So if that's something that, you know, you're concerned about, that's an interesting thing to know. I thought it was helpful. So there were a lot of articles that we really couldn't get to this month, but I just wanted to kind of mention we're going to have a Shock Abbott next month where he's going to go through the DLM calculator. There was this actuarial risk article in BV Update, as well as, you know, some research that was interesting talking about ESG and women and in leadership. So those were all really interesting. There was an Arizona case on goodwill. And there was a vineyard case. Okay, so here's some articles you may check out. Thought it was very interesting. There was a lot to go through this month. Next month, I'm also very excited about some of the articles that we'll be discussing and kind of introducing you to, so that you have those resources available. As always, reach out if you have any feedback or any questions on anything that we've talked about today. But with that, I am going to give it back to Alina so that she can hand it over to the judges and you guys can hear everything that they have to say.
Thank you, Janae. Yeah, we have a lot of information this month. That was very interesting. And for those of you that are asking about the polling question, you have it in front of you right now. So make sure you respond to that. And now we have Roberto Castro. He is going to be interviewing our esteemed judges, Judge Platt, Judge Yates, and Judge Driscoll. And it's a very interesting topic. It just reminded me of my grandma when I was doing something wrong, and she was like, watch what you say, in Spanish, obviously. So this is going to be an interesting topic. Roberto, thank you for being with us today, and the judges too.
My pleasure. Let's make sure that we have the slides showing at this point. Can you see the slides?
Not yet.
Can you see them? Not yet? Okay, so let me just make sure that we're sharing that. Share. And here we go. Well, let's open it up. There we go. How's that?
There we go.
Perfect. Okay. Excellent. So greetings, Judge, and greetings, members of NACPA, of Around Evaluation World. So today we're going to be providing some hypothetical examples of what not to say. And this is based out of an article that was published or will be published shortly by Miranda Castell of the Pachter Law Firm. So whether you're a valuation analyst or alternatively a litigation consultant, keep these examples in mind because this is something that can be very helpful to you. So we'll start off here with a little bit of background, and you can look at that. Oops, somehow we've skipped through it. So let's talk about the discovery, first of all, judges. Very often you'll have individuals that may potentially have emails or memos that may be potentially include information that if a judge saw or somebody else saw may perhaps cast some doubts as to their bias. So hypothetically, if an expert is not retained by an attorney, they're dealing directly with a company or an in-money spouse. Judges, let's talk about what is that discoverable, and what, in theory, is there some way to prevent that information from being discovered? Let's start with that, Judge Yates.
If you think about what is subject to discovery and what is not subject to discovery, the first place to start is that everything that is either attorney-client or accountant-client privileged is generally not subject to discovery, nor is work product subject to discovery. In other words, what an attorney puts together. Beyond that, though, I think you have to worry about absolutely everything being subject to discovery because, in general, the rules of discovery are much broader than the rules of evidence. Each state has its own rules, but in Michigan, for example, anything that could lead to the discovery of admissible evidence is itself discoverable. And I spent a lot of time working on rewriting the rules of discovery in Michigan, and I can tell you that it's very hard to accept something, EXCEPT, from the discovery process unless you're talking to an attorney.
So hypothetically, let's say an expert or a valuation analyst is dealing directly with a client and there's correspondence going back and forth. Is that, in theory, the emails, the memos, the phone text, are those in theory available or discoverable by the opposing party if push comes to shove?
I would say yes. I'd be glad to hear what my colleagues have to say. The work product privilege, the work product rule, it's not a privilege, generally applies to the work of the attorneys on the case, not to the experts on the case.
Yeah, I would just add to that. I mean, everything that Judge Yates just said which is the framework for any analysis that anybody is going to have. My question is, and I hate to answer the hypothetical with a lawyer like it depends answer, but it really does depend where it fits into that framework. And an example of that is, not quite sure in what context this comes up, because if you have an attorney, presumably the only person entitled to discovery as such is the other side and the other attorney. That's what so the hypothetical presumably is, at that point the other attorney is dealing with the attorney, not the owner, even if the owner hired the expert. I think that would cause great focus on any retainer agreement you have. I'm not sure why anybody would want, if there's an attorney involved, I have no idea why the client would want to be the one to do this, considering that the client can't avail themselves of either the work product rule or the attorney-client privilege. So the best thing that the client can do is listen to and let the lawyer handle it, especially if you want to shield any of this information.
And that's exactly the risk that is faced when there's not an attorney involved in the communication. So as Judge Yates started out saying, that the work product privilege is designed to protect a lawyer's thoughts and mental impressions and the lawyer's trial preparation. Well, notice that the lawyer is part of that explanation. It's not meant to protect the expert's trial preparation unless that is part of strategy discussed with the lawyer. So if the expert's emails say something like, gee, we've got the best methodology here and the other side's methodology is horrible and here's how we're going to explain it, that might not be discoverable because it does set forth strategy. The question whether that kind of communication is really going to happen without the lawyer involved, I don't think it happens that often. And
doesn't happen at all. Okay.
But I can see why the expert might speak with the client directly. The client wants to save money, and if the client's not paying the lawyer's fees, the client's happier about that. So our dear experts who are here, tell retaining counsel to impress upon the client that your communication should be with retained counsel, or should at least be CCing retained counsel. So at least there is the veneer of strategy being involved in your communications, because as Judge Yates and Judge Platt said, if you're just talking to the client without the lawyer being part of it, it's much harder to show that there is strategy or thoughts or mental impressions that are the lawyer's thoughts and mental impressions that would otherwise be protected from discovery.
Yeah, I agree with everything that everybody said. I just want to add one more point. It's remarkable to me in my experience working through discovery disputes that if there is an attorney on an email discussion, everybody backs right off and acts like, well, we can't ask for that. Clearly, that's going to be attorney-client privilege, even though I can often see an argument around it being attorney-client privilege. But the value of having an attorney on an email discussion is much greater than I would have imagined it can be.
And the other part about having the attorney on is it lets the client know, hey, this is serious, because clients might talk to other folks. A client might talk to their best friend. They might talk to whomever. And all of a sudden, to the extent there was any kind of privilege or protection, that's vitiated the minute the client is talking to somebody outside that circle of trust. So the conversation between expert and client involving the lawyer also is a way to help impress upon the client, hey, client, you reveal this information at your peril.
Well,
Yep, good point.
and also, again, along that same theme, I mean, if you think about it, if you want a red line or a bright line is expert communicates with lawyer and the client is an observer. And any direct communication, I mean, I would even caution not to just think that just because you copy counsel on it, that's going to protect it. Why worry about it when you can do it another way and be sure?
What about, I'm going to throw a hypothetical. What about communication between, say, the expert and their staff? Is that discoverable?
The expert and the expert staff?
Yes.
I think we still come down to the question whether
Mhm.
there is strategy being discussed. So if the expert
Mhm.
is saying, hey, retaining counsel has asked us to analyze these 3 different ways of interpreting this because one might be more helpful than the other, and essentially expert is incorporating counsel's strategy, I don't think that's as readily discoverable as, hey, let's run 3 different sets of calculations here.
Mhm.
And
Or-
you're going
or
to
in-
have
or-
you're going to have in discovery disputes, because of the framework that Judge Yates introduced into this conversation the first thing right off the bat. If there's an attorney involved, whether it's and an expert involved, the expert staff automatically, if they don't want it disclosed, there will be a work product and or attorney-client privilege issue raised, period.
Mhm.
So the answer to this isn't yes or no. And I know this will come as a shock. There are different judges who have different perceptions of these rules. Some think that right off the bat, if it's a lawyer involved, particularly if there's any kind of strategy, again, I would focus, but only because I've seen just crazy retainer agreements that announce in the retainer agreement, if you hire me, this is what I will, this is the opinion I will offer. You got to be out of your mind. Okay.
Yeah. Agreed.
That's strategy, dumb strategy.
It is.
Not necessary to reveal it. The retainer agreement ought to be between you and the attorney. And frankly, the client's role depends on what the attorney's relationship with the client is.
So let's suppose that the material is discoverable, and we'll take an easy example. Let's say that the expert indicates that he or she always wins cases. And again, this is part of our marketing campaign, and they say they're the greatest expert in the world. And that whatever they say goes. How does that strike you? Is that, again, you've got potentially a Daubert motion or a motion to disqualify the expert for lack of for basically being biased. What are your initial impressions if you've got somebody who's boasting and saying how great that they are and that they know
that's terrific.
far
I hope their mother is proud of them. I hope their mother is proud of them. But in terms of the Rule 702 factors, it's braggadocio is not a basis for exclusion. It goes to weight, potentially not admissibility. So if please don't put in your marketing brochures that you're the greatest in the world. Let others speak for you rather than you speaking for you, I guess would be the practical advice. But as a Rule 702 matter, it's not really of any moment because it doesn't go to the essential 4 elements of Rule 702. I'm pretty strong in that view, and I think I can speak for the other judges that on that. But I'm sorry, I shouldn't speak for you.
Sure you can.
Well, I certainly would say that I've seen experts get destroyed by material that's online. You have to be very careful what you put on your LinkedIn, what you put on your firm website. I mean, you can rest assured the other side in preparing to cross-examine you is going to take a look at all of that. Even what you go up with on social media.
And I'll pick up on that comment. Is there anything that you've seen in social media or in a marketing campaign that would suggest that perhaps this person is not an unbiased expert?
Sure.
And that, okay. So
Yes.
what advice would you give to the listeners here as to what not to include that may taint their perception of being unbiased?
Well, I think you can talk about your factual successes, your experience, how many years you've been in the industry, what your certifications are, the number of times you've testified, all that, as long as it's factually accurate, that's not going to come back to bite you. But when you start engaging in hyperbole, boy, you can really get beaten about the head and shoulders with that.
Okay. So let's say that the discovery, during the course of discovery, they find that the expert says, I'm just going to use this because it's the most favorable assumption for you, and it's not going to cost you as much. What's your impression?
Where would they say that? That's an example of what we're talking about.
You know, maybe a text between the expert and the client. And again, this is the hypothetical where the client is attempting to save money, wants to make sure that they're not paying too much, wants to make sure that the expert is on their side. They don't understand that the expert is testifying for the court.
And the attorney is involved or not involved in that?
Not involved. Let's say it's not
involved.
The attorney is not involved or not kept in the loop.
Back to Judge Yates and Judge Driscoll's answer. You just lost most of your protection.
Yeah. And don't nobody talk no more, as we say on Long Island, late at night. Don't nobody talk. So,
Or what did Yogi Berra say? Right? Doesn't anybody here know how to play this game?
Yeah.
Right. So, clients texting you all the time. Hey, give me a call. Give me a call.
Right.
That's right.
Let's talk about this
exactly.
a little bit, right?
Yeah. That's right.
The lost art of telephone. Some of this stuff is best said in a telephone conversation.
Right.
And not in an email or a text.
But you're opening,
and that's true of a lot of different comments, particularly even strategy, which the first rule is do no harm. The minute you start dealing directly with the client and the expert, you just gave up a bunch of protection, which means you did some harm.
Well,
expose yourself unnecessarily.
And you think about it, there's no nuance in a text either. And I just look at that over the weekends. My wife sent me a text saying, would you like to go out to dinner? I wrote back, very nice. And she calls me immediately and says, what do you mean by that? Very nice. I'm like, honey, very nice. Very nice idea. There was no nuance in it. There was no nuance. I should have just called her and said, sweetie, that's great. Whatever you want. Right? So again, there's no nuance in a text. So the less you text with your client, the better it is for you, because it's not discoverable and there's no question about what's in there. And of course, text can be easily forwarded. Unless someone's recording your conversations, they're not as easily forwarded.
Right. But then again, are you advising people to engage in telephone communications? Because otherwise, if you know, okay.
No, I'm saying the less you say, the better. There's an Irish song, and the refrain is, whatever you say nothing. And you talk about you know what, because if you know who should hear you, you know what you get. So don't talk to the client. Cash the client's check, but talk to them when a lawyer's around.
Okay.
And there's no argument to the contrary. None.
Okay. If
except by the client who wants to save money. Well, I don't understand how they think they're saving money by not. I've heard I don't want to involve the expert because I don't want to pay the expert. I've never heard of anybody saying I want an expert, but I don't want a lawyer. That would bother the bar associations of this country a lot.
Right. Now, I'll pick up on the comment about the bar association. Have you had an occasion where you've had concerns with an expert's unbiased, lack of bias, and the attorney being on board and knowing that perhaps this expert is not unbiased? And I don't know if you've had those situations, and if you had, have you? What besides not allowing the testimony or discounting the testimony, are there any possible ethical concerns that the attorney and the expert should have?
Well, it's the lawyer's not suborning perjury. That's of course the initial concern. If the lawyer is bringing on an expert that isn't great or isn't as great as the expert could be because the expert's methodology is suspect. Well, of course, Galbert and 702 give you a basis to potentially exclude. Although, as three of us have said previously, we're probably loath to exercise that, particularly if it would prejudice one side. So I know Judge Yates's common practice, which I really like, is if he's going to exclude the expert, he's going to give that party more time to get an expert because he doesn't want that decision to be outcome determinative. So I think we are hesitant to ever exclude an expert, and if it's simply a question of not using the best methodology, well, the adversary system should be able to expose that, just like the adversary system should be able to expose any potential bias or predisposition that the expert might have.
And I'll say this about bias. The U.S. Supreme Court has said at least twice that bias is always an issue, even though it's not mentioned in the rules of evidence. But when somebody talks to me as the trial judge about bias, my reaction is I'm not going to exclude the testimony on that basis. It goes to its weight, not its admissibility. I'll let you have all the cross-examination in the world you want to try to expose bias. But I would really be hard-pressed to ever say an expert can't testify just because the expert's biased.
Realistically, counsel hired the expert, presumably if counsel understood or researched the expert's ability on the ability of the expert to persuade a trier of fact, be it a judge, a jury, or even that matter, an arbitrator, or even a mediator, not on the basis of anything else. They're not going to be able to persuade right off the bat if they're perceived to be biased. But he didn't hire them because they weren't biased. He hired them for that reason. I represented a doctor who wrote a book on how doctors should testify in court, and cross-examination was inevitable, and he went both ways. He wasn't biased. Whoever had the most money, he went with him. On page 56 of his books, he said certain things, and cross-examination inevitably was, doctor, did you answer the question on direct examination, whatever it was, because that is the truth and that is and you were under oath, or did you do it because on page 56 of your book it said, if you get asked this question, answer this way? And his answer was both. But he was an effective expert witness for either side, and he was biased to whoever paid him. And it's going to be very hard to convince a trier of fact who has any background and experience that somebody that gets hired by somebody is not going to at least do the best they can to voice the opinion that will help the case for the person who hired him. And even if that's not true of certain, I can't imagine the expert who does that. But if it's not true, it's still a problem because the trier of fact thinks it's a problem. The question is he persuasive enough to overcome the prejudice?
Yep. That's a good way to frame it.
And some are, some aren't. I also had an experience where I spent 4 days deciding whether two doctors who probably make a living going around the country opposing each other's point of view, and their own argument on voir dire was, I'm the most qualified because if you go check this topic on Google, you'll find that I'm quoted 756 times. My opponent, who's sitting out there, and the opponent on the other side is only quoted 456 times. And cross-examination there was, of the 756 times, how many of the comments were critical? And he had no answer for that. But people, we live in a cynical world, and the cynicism pervades this area. So I think the bottom line from this program is the expert and the lawyer. That should be the movie. That should be what's seen in a courtroom, and not the expert and the client, which just adds to the problem of overcoming the perceived bias. And secondly, attorney-client privilege and work product don't apply if it's anyone other than the lawyer. doing the communicating, and maybe the third is reinvent the telephone.
Right. I had one question from one of the participants, and the question is, what about raw work in progress data? Is that something like an Excel model? Is that something that would be discoverable? And again, this is from the expert or the business valuation consultant.
Depends on who it was for.
Okay, if they're doing it for a client that again, pre-litigation, is that something that would be readily discoverable? Or rather, let's say two hypotheticals. One of them, it was prepared during the course of an engagement, and then subsequently they're now in litigation and they're using the same model. Is that are any of the
again, I'm not trying to monopolize the conversation.
Right.
I haven't, and I'd be interested if my colleagues. I've not had very many cases where the client hired the expert and the lawyer, whatever. But if that happened, I suspect the lawyer would adopt anything like that in particular as his work product. Maybe it wasn't at first, but it is now. And that would be the argument.
Okay.
I guess my view would be, is it data? If it's data, it's discoverable. If
Right.
it's actual drafts or analysis, probably not discoverable. So that would be the easiest way I would think about it.
Yeah, I agree with what Judge Driscoll just said there. I mean, I think that although the work product doctrine doesn't apply to experts in the same way it applies to attorneys, I would be loath to have a lawyer cross-examine an expert about something that the expert left on the cutting room floor when the expert was working through potential models. I mean, I'm not saying I wouldn't allow it under some circumstances, but I mean, everybody does some work before they finally get to the answer, whatever the answer is, and that's understandable. You want them to do that. So as a trial judge, I'd be more protective of that. But data, Judge Driscoll's right. That's just simply going to be discoverable.
Well, me too on both those comments.
Yep.
Well, I think that concludes the this portion of the around evaluation world. I think there's a second poll that's come out here. Judges, thank you so much for sharing your comments and participating in this webinar. Appreciate it.
Thank you.
You're most welcome.
So much.
Thank you.
Take care.
Yep. Good to see everybody.
Bye-bye, everybody.
Thank you. Okay.
Thank you to Roberto and to all the judges that were with us during this month. And now we are going to have Arli. So you have, she's have joined us before, so you might already know her. She's Arli Cornejal, and she's the finance program manager at Start Small, Think Big. And as I mentioned, Arli has been with us before, and Arli, is always a pleasure to have you back. So for those who haven't met you yet, let's talk a little bit about doing a quick introduction about Start Small and Think Big. And can you tell us a bit about what the organization does and how your work helps small business owners thrive?
Yes, thank you for having me here today. So we are, Subtle to Make is a national based nonprofit. We offer services to entrepreneurs completely pro bono, and we rely on volunteers. So we're actually looking for volunteers to join our organization. So we have finance and legal volunteers, and they help our entrepreneurs with projections, with bookkeeping, with contracts and the legal landscape.
Oh, so that's part of the mission. And how does Start Small Think Big support entrepreneurs with financial services?
Yes. So right now we support entrepreneurs with two areas of bookkeeping, projections, and pricing cost analysis. So with bookkeeping, we have accounting volunteers that help our entrepreneurs kind of get to know the softwares that are out there, and there are many out there. So setting up the software and then maybe some cleanup as well. And then for projections and pricing, we help entrepreneurs kind of think about through their templates that exist that we have to kind of go over their pricing, go over maybe how they want to change their business, etc. So a few options, and the entrepreneurs really find these 1 hour calls really helpful for their business.
That's great. And I think, Shanda, it's slide 36. So the next one, if you can help us with that, that's the mission for all of you. When I know some people ask about the presentation is on the chat. So if you need to go to the chat and look for our PDF, you will see the presentation, including these slides from Arli. So if you can pass to the next one, Shanda. I know that it is very interesting, especially in this time, that you serves an incredible range of entrepreneurs, including women, BIPOC founders, immigrants, the LGBTQIA plus business owners. And in the next slide, Shanda, then you will have what she was discussing about the different services, right? This is the
Yeah, it's a bit about
um,
impact. Yeah, I think in 2 more slides from here, you'll see a little bit about what we offer. So how you can also get involved with the work that we do. So actually, we're working with NACPA on December 3rd to have our corporate day of service. This really is. So we work with different banks, different institutions like NACPA to kind of get everyone into the same room. So it'll be our next call. We just had one in September, but our next one is in December 3rd. And we'll have about 10 to 16 entrepreneurs, and they'll be supported by um, hopefully 20 NACWA volunteers. So you're welcome to sign up. Hopefully Chana can add the sign up link in the chat. This is be 4 to 5 p.m. East Coast time. And so, it's 1 hour you're giving to entrepreneurs to kind of support them through thinking about projections, cost analysis. You'll have a template that we'll send you that you can use with entrepreneurs. Yes, a great opportunity to volunteer. We also have 3 other options. You can also work with us to lead small group sessions, and these are on topics like financial projections, bookkeeping, pitch deck, capital access. Same thing, webinars or workshops. Those are open to the public. And those are 1 hour led, and similar topics looking volunteers to lead those sessions as well. And lastly, if you're not available December 3rd, you can also apply to be volunteer at that chat in a few minutes. And you can just sign up to be volunteer, work with entrepreneurs in accounting or price cost analysis in one-to-one sessions.
That is great. And I know on the previous slide, there was an average of 50% revenue increase among entrepreneurs who complete your program. I think it was we were just ahead a little bit, Chanda. It's before the one 30, 41 maybe? I don't remember, but it's okay. So in that slide that we were talking about a 50% revenue increase among entrepreneurs who completed your program, I think that is, an incredible impact. Could you share a story of one business owner or some samples that business owner that went through the program and saw a real transformation? Maybe what changed for them? What is better financial organization, clearer pricing, or maybe new sense of confidence in managing their money?
Yes, for sure. So, we have our clients have to reapply every year. So it's great when our clients kind of are no longer eligible because I mean they've grown and they're too big now to be eligible for our services. We definitely have had entrepreneurs that have really expanded their business, that maybe have wanted to move to a brick and mortar. We've kind of supported them with thinking about making that move. We definitely have had many great businesses come through our doors. And even small things, maybe some entrepreneurs just needs help thinking about how to pay themselves, or whether they're ready to take on an employee. So these are really helpful things to kind of brainstorm with another like financial expert, since they're probably just learning as they go about the business finance landscape.
Okay, that's great. And for us as business evaluator, maybe we don't think about, oh, maybe we're a fractional CFO or offer accounting, but we have the expertise, right? So we can help in a lot of ways to these business owners as volunteers. And I can imagine how you can feel, as you mentioned, when a business owner comes and it doesn't qualify. It may be sad in a way because they are not longer with us, but that means that they grew and they are being successful with their with their business. So when you mention that they don't qualify for your services, who is eligible to receive financial and legal assistance from Start Small Think Big?
Yes, so we take businesses from all across the US, all 50 states, and we just would like to see at least 3 months of sales, at least $100 per month. So not very high. So after that, you're eligible to receive services for 1 year. But we only offer legal services to clients in New York and California. But finance is offered to all 50 states.
Okay. So I guess when you say that they don't qualify, is because of revenues or when they start qualifying for your services in terms of, I guess, financial services?
Yes, yeah. So once you're onboarded to be part of our program, you're eligible for finance services. So we just need at least 3 months of sales.
Okay. So how does Start Small Think Big collaborate with other organizations to enhance its support for entrepreneurs?
Yeah, so we definitely look to partner with different organizations to have our corporate day of service. So as I mentioned, we're working with NACWA, December 3rd. We've worked with Citibank to kind of get panelists for our webinars that we've done with cooperative services of other banks, Blackstone. So we definitely have had many partners. We kind of rely on our partners to come and support our entrepreneurs either one-to-one or in small group sessions or webinars.
Are there any fees that those entrepreneurs seeking financial or legal services need to pay when they are going through Start Small or Think Big to your organization?
Yes. So we don't have any fees associated with being a client. We offer services for finance pro bono, and any legal fees that might come up will be paid by our legal partners.
Great. So anything else that you think that we may know about the program and how can we collaborate more going through a website if we are interested in
Yes.
helping the organization, how we can do that?
So you're welcome to share about our organization to other business owners that you might know that might be eligible for our services. And you're also welcome to volunteer with us. Definitely always looking for volunteers to support our entrepreneurs in either bookkeeping and projections. We also have our upcoming event, December 3rd, as I mentioned before, that you're welcome to sign up for as well.
When is that? Can you repeat that for us?
December 3rd, December 2nd, sorry, 4 to 5 p.m.
Is that the AA, the e-finance series that you mentioned?
Yeah,
I said
this is our kind of our corporate day of service. So just you'll be able to work with entrepreneurs one-to-one during that session for 1 hour.
okay. So for the other opportunities that are in your presentation that are not one-to-one, maybe having a small group and all that, they will coordinate with the volunteer when those can be arranged and the type of entrepreneurs they're going to be assisting, right?
Yes. So if you would like to volunteer in other ways, you're definitely welcome to apply to be a volunteer with us. So you can kind of attend our orientation. So I'll drop that link down below and that way you can volunteer one-to-one, throughout the end of the year, or you can volunteer through our webinars or small group sessions as well.
Perfect. For everyone, there's Shanda just put on the chat, you will have in there the registration link, so you can go over that and fill that if you want to help. So anything else, Arli, that you want to tell us about the organization or the services, or how we can help?
Yes, I think we've covered it all. So I just hope that all of you will sign up or tell someone that you know to sign up to our pro bono day of service. So I hope to see some of you there. And please let me know if you have any questions. You can always email me and also drop my email down below as well. But thank you for
Thank you. So thank you so much for sharing your time and insight with us and for the incredible work that you're doing to make finance accessible and empowering for a small business owner, because I know it's so much needed. And every time you join us, we are reminded that good finance isn't just about numbers, right? It's about opportunity and about community, just helping others. So thanks, Arli, for being with us, and we'll see you next time.
All right, thank you so much. Bye.
Thank you. And you have in front of you the next polling question. So make sure you respond to that if you're waiting for your CPE credits. And in front of you, you have artificial intelligence resources. But I guess we are going to our next presentation. We are going to have Shonda that he's going to present you the December Virtual Summit and AI, right, Shonda?
Yeah, I just want to do a quick announcement
Great.
regarding the two of those. With our AI resources and webinar series, just want to remind everybody that there is a free webinar that's available on the website. So if you go to the AI Valuation and Forensics Primer or follow that QR code, it'll take you to the recording of that. And then on that same page on the left-hand side, there's a bunch of different webinars that we've done in the past related to AI that will help you as you navigate through this new feature in the industry now. So just here and everywhere else, it's all around. So we do have that. So that is available. If you have any questions, please feel free to let us know. We are launching webinars every 2 weeks that are related to AI in the industry as well. And then also in December, we do have our virtual summit that is coming up. It's similar to our conference. I'll have different presentations from various subject matter experts in the industry. So if you do need your CPE, you're in CPE to recertify. It's a great opportunity to get that in. There's a QR code there as well, so go ahead and scan that or visit the nacb.com/summit for more information about that. And with that, I'm going to turn it back over to Alina, who will get us started with the next presentation.
Yes. So now we are going to have Stephen White. Are you with us, Stephen? I know he was.
I am here.
Great. It's great having Stephen with us today. He's coming from Jersey, and he's going to be interviewing Mr. Ekeu, and they are going to be talking about the impact of tariffs on small business valuations. So we keep talking about small businesses, right? They are the largest type of businesses in our economy. So I think they're really important. And we're going to be talking about risk realities and best practices. So, Stephen?
I am here. Good morning, good afternoon, everyone. Having a little technical difficulties here with our video, so hopefully everyone can hear me. I apologize about that, but I have the distinct pleasure of interviewing today Achille Ekeu. He is going to be going over a presentation that he'll be delivering later on this afternoon, the impact of tariffs, small business valuations, risk, reality, and best practices. But for those of you who are not familiar with, you can see his bio right here on the screen. He's a former state chapter president for Washington, D.C. and Maryland. He's a former NACVA elected board member on the Valuation Credentialing Board and current founder and CEO of the Washington Valuation Group. Achille is a seasoned business valuation expert with extensive experience in financial analysis as well as strategic consulting, proven track record, executing high-profile valuations engagements across the industry with expertise in estate and gift tax matters, acquisitions, shareholder disputes, as well as business transactions. So, Achille, how are you doing today, sir?
Hey, I'm doing very well, Stephen.
Good. I'm glad to have an opportunity to chat with you because this is one of those topics that everyone's been talking about a great deal for the last 9 months of this year. So this is a timely presentation. I know you've talked about this before, but this is truly still a very timely presentation to discuss with this particular community. But I also thought it might be interesting if we took it a step back just for a moment, because we hear that word tariffs a lot. And a lot of people aren't familiar with the fact that tariffs is nothing new. It's been around since 1789. And in fact, it was the first major piece of legislation that was actually instituted before the ratification of the Constitution. That being said, you think about what was the purpose of it. It was for three different reasons. One, to support the government. Second was to protect the manufacturing industry. And then the third, which was to raise revenue for the federal debt. So that was the original purpose of tariffs. Why don't you give the audience an overview of exactly where are we today as it stands with tariffs?
Right. So you just thank you so much for this nice introduction, by the way. It's just going to make sure that I acknowledge that nice introduction of yours. Thank you very much.
No problem.
Listen, this is the third time I'm doing this presentation. The first one was on July 30th. The second time at the national conference, and then this time today. So the idea is that we are in a situation that is unprecedented, right? So it's tariff has been a subject of discussions for the past few years. I think since the first Trump administration, we've been talking about tariffs. But this time around, it's been at the forefront of every news and every event that we hear on the news. So the idea is, what is the impact of that tariff on small businesses? And that's the premises of my research. And so I try to figure out, with so much tariff being, talked about today, the impact of tariff of decisions that are being made by the current government and the impact of those decisions on small businesses. How do we, as business valuation experts, account for that? How do we measure the impact of that tariff on small businesses? And that's the idea that drew me into doing some analysis, some research to figure out, what is it that we can do as business valuation experts to try to incorporate the impact of that tariff within our work. But that started by first doing a little bit of assessment of the current condition in the market today. And then so we see that the sweeping tariff policies that was enacted this year have fundamentally altered the business valuation landscape by introducing significant new risk and uncertainties, particularly for companies with high import dependencies, right? So when we look at the weighted average U.S. tariff rate today, it went from 2.2% to over 17, even 20% now. And that's a dramatic increase, that we haven't seen for the past, at least for the past 100 years, So this change, is really forcing valuation experts that we are to move beyond traditional models or traditional models and incorporate those multifaceted impacts of tariffs into our work, and that includes the cost escalation, the disruption of supply chains, the competitive repositioning that companies have to do, and the current volatility and other macroeconomic effects into our work. So that is pretty much the answer I can provide you for this question, but it's even deeper when we're going to talk about that.
Sure.
4 o'clock later.
Yeah. I this is, even though you're doing one session on this, is truly one of those areas for small businesses. I think it has a significant impact, and it could be an entire week course to actually talk about those things. But let me ask you this. I know that during your presentation, you're going to go into different critical risk factors. Why don't you walk us through what are some of the most critical factors when you're assessing or valuing a business that have been exposed to tariffs?
Right. So what we did was,
or better yet, let me rephrase that. I know that in your presentation, you have something in there referred to as your 6 factors. So maybe you can walk through that overall process.
Exactly.
Sorry.
So that is what it is. So it essentially we've been able to come up with a framework it's called the risk assessment model or risk assessment model, if you want it, whether you prefer model or model. And that risk assessment model is a 6-factor risk assessment model based on the other risk assessment tool that we've already used in the past. And here, the critical factors that we've uncovered, the first one is the import dependency, right? That's the first dependent factor that we uncovered. So this is a percentage of input sourced from tariff affected countries. So so how do companies how much dependency they have for their raw materials from abroad, from a foreign country. So we have to assess how much dependency they have. And then there's a geographic concentration that's also another factor. Do those companies have diversified suppliers, or do they get all their suppliers from one company, from one region, or from one area, or from one geographic area? So all these, we have to assess that. And then in terms of supplier alternative, how much availability of supplier sources do those companies have? And we have to be able to identify that. And so the fourth factor is the price elasticity, right? The price elasticity, it's the customer sensitivity, to price increases that result from tariff. And so then the fifth one is the financial flexibility. So the firm's balance sheet, that's the first balance sheet capacity to absorb increased cost due to those tariffs. And the sixth one is the management capability. The management has a track record of managing or adapting to crisis, and what kind of strategic response do they provide? So those are the 6 different factors that we'll be able to identify, and that we incorporate in that framework, and that allows us to be able to assess, how companies are able to, to withstand or to be able to manage, this tariff situation that we're facing right now.
Okay. Thinking through each one of those particular steps that you just went through, it kind of lines us up to go right into your methodologies. Janae, if you can go to page 6, I think this is a really good slide to dissect. One more. Keep going. One more. Should be one more. Yes, right here. So again, I am going to be repetitive, and I know you're going to go over this stuff in more detail later on this afternoon, but I think it'd be great for our audience, knowing your 6 factors that you just described to us. How does all of that apply when you need to make the adjustments as far as valuing these small businesses as it applies to the tariffs? And I think this slide kind of gives us a really good grounding point here to start off with.
Right. So, before I answer that question, I want to say that there's from the 6 factors that were identified, we are able to score them from a low risk to a medium risk to a high risk. So based on that scoring, we then are able to assess how much exposure some of the companies that we're going to be valuing, how much exposure they have. So to answer this question, then we have to do what we have to figure out how to adjust, our methodologies, to fit the situation that we have, for our client. And in our work, we have to use different methodologies, right? So we have the DCF for income approach, the market multiples for the market approach, and the asset approach. So, for the DCF, we have to look at the revenue projections. Then we have to move beyond the historical trends that we have to model demand elasticity and competitive responses to tariff-driven price changes. So that is an element that is very important. The cost structure also is one of the elements that we need to focus on the discount cash flow. And and here it's about modeling direct increases of input cost, right? And especially when it comes to pass-through effects and supply chain complexities. And we have the discount rate adjustment that we also have to consider. Here, we'll be talking about increasing the cost of capital via a higher beta, the beta in terms of risk and a specific country policy or country or policy risk premium that we have to affect to that specific company. And so at the end, we have the terminal value. That's a second, that's another option. Here we have to see whether we can lower the terminal growth rate to reflect a long-term structural headwinds. So that's for the discount rate. For the market approach, we have the comparable criteria that we need to be able to, to determine, the comparable selection criteria that we have to determine. Here, we talk about adjusting peer group selections to explicitly include companies with similar tariff exposures, supply chain geographies, and import dependency ratios. And we have also multiple adjustments. Here, we talk about applying quantitative adjustments for supply chain flexibility and geographic diversification, as well as management track record and financial strength. For the asset approach, we have to consider inventory valuations, meaning we have to incorporate risk of inventory, or inventory obsolescence due to disrupted supply sources or regulatory changes. And secondly, we have to consider replacement cost. We have to adjust the asset values for higher replacement cost and longer lead times due to tariff. And finally, we have, in terms of working capital, we have to factor in changes to working capital requirements arising from supply chain shift or required inventory buffers. So if we adopt these tailored adjustment, we can then provide defensible valuation report that are going to capture the full economic impact of tariffs, ensuring valuation outcomes accurately reflect heightened trade policy risk.
So, John, if you can go to the next slide, that'll be great. We can talk about the industry-specific impact analysis. Joe, why don't you walk us through this particular slide here?
Okay, so that slide is talking about industry-specific risk, which means that some industries have higher exposures than others, right? So we have, high exposures, medium exposures for technology companies, high exposures manufacturing, raw materials. Those companies depend mostly on raw materials. Retail consumers that depend mostly on imported goods reliance, and medium companies, medium industries, technology companies who rely on component sourcing, and low exposure company that are generally services company that are limited in direct exposure. So these slides talked about those different exposures, and so we look at the different industries. The steel and aluminum manufacturing industry has a raw material exposure cost, right? And so this typically impacts between 15 to 30% cost increases. And in terms of valuation multiple adjustment, there's a compression between -20 to -35%. Those companies within that industry are going to have to incur. So the consumer electronics industry has a component sourcing exposure that impacts the company in terms of cost increases between 8 to 20%. And the valuation multiple adjustment or compression will be also between -15% to -25%. The apparel textile industry has an exposure of finished goods, and then the impact in terms of cost increases is between 10 to 25%. And so this also leads to valuation multiple adjustment or compression of -20 to -30%. And finally, the agricultural industry, has a retaliatory tariff exposure that is very critical, and the impact ranges between 5 to 40%, revenue losses. And in terms of valuation multiple adjustment, we have to consider -10 to -50% even. So that tells you that it's, depending on the type of industry, the compression, the impact of tariff
Right.
very, very dire or very, very hard on some of the companies that are involved in those industries.
Well, I know that we're kind of approaching the tail end of this particular segment, but I would like to go into another area. Well, basically sticking with your high area, which is in manufacturing, which is kind of interesting, being that manufacturing was one of the three areas of what started the overall tariffs. Can you walk us through a case study on manufacturing? Jordan, if you can go to the next slide, I believe it begins there. Yes. Kind of walk us through this particular scenario here as far as a manufacturing company.
All right. So this document includes a case study of a mid-sized industrial component manufacturer with about 60% of raw materials sourced from China, right? So, in terms of pre-tariff, let's say 2024, the revenue was $50 million. Post-tariff, that revenue went down to $45 million. And the impact, if we assess that, is minus 10%. The gross margin is going to go from pre-tariff 35% to 22% post-tariff. So that accounts for 13% in terms of minus 13% in terms of impact. The EBITDA of the company is going from pre-tariff $8 million to post-tariff $4 million. We see that's 50% impact already on the EBITDA. And so in terms of valuation multiples, well, pre-tariff it was 6.5x EBITDA, post-tariff 4.8x, and the impact in terms of percentage is minus 26%. In terms of enterprise value, well, pre-tariff, the companies were valued at $52 million, post-tariff $19.2 million. This is how impactful this is. That's a loss of 63% of value. So it's really, really hard on many companies. So we don't see that, but definitely when we do analysis, we can see that it's really having a serious impact on companies' values.
Wow, this is truly impressive because if you think about it, like I said, if we broke down the types of industries that we deal with here and the associations, you'd be surprised to see the number of companies that we deal with are manufacturing companies. And this is truly an area that I think you'll gather a lot of questions later on today as far as how this actually would impact their overall businesses and how they're actually working with them and seeing pre-tariffs as well as post-tariffs. Right. And also knowing where they're coming from. And this one was drawn from China, but there's so many other countries that are involved in this tariff war as well. How does one go about, you utilize this one from China, let's just say other countries that are being hit with tariffs. How do you approach that? Do you approach it in the same manner, or how does one go about getting information to help them with this?
Well, the important here, I mean, we professionals have to be the one that really work with those companies to assess the impact of tariff on those companies, because as we know, the issue with tariffs today is that it fluctuates. One day it's 30%, the next day it's 100%. I recently heard people talking about President Trump trying to raise tariff on China 500%. It varies so much. Nothing is stable, but all these disruptions are creating a lot of issues, for small businesses. So here we're trying to repertoriate, the main industry that are mostly affected, especially companies that are depending too much on China. Now, if you source your products from different countries, maybe close countries like Mexico, maybe Canada, something around, it may not be the same thing, right? So it may not be the same thing. So it all varies. It all depends on the geographic location. Well, the assessment tool that we have, that we provided, the framework that we provided, is going to help us determine the exposure, because here, remember, we have to account for low risk, medium risk, and high risk in terms of exposure. So once we do that, then we'll be able to understand where these companies stand in terms of.
Okay. Someone put in the chat, and I'll just read it out. Seems like very high impacts and overstatement of impacts. any consideration and assumptions regarding how long these tariffs will last. The current president will only be in office another 3 years.
Right. So this is all depends on what's going to happen within the next 3 years. Are they going to put those tariffs in a formal, law or regulation or anything like that? We don't know that yet. So
Right.
as of now, it's just executive decisions by the current president. But what if they get put into law? What if they get put into regulations or things like that? We don't know how long it's going to drag, how long it's going to go. So it's in the meantime, small businesses are suffering from those decisions. So that's where we are, and now we don't think it's going to disappear with the current president leaving office. We think there are some benefits to tariff, definitely. Are we going to? Is the next president going to overrule or discard those benefits?
Right.
We're not sure. So we see it depends on, it's going to depend on each president. It's going to depend on Congress and what happens,
Yeah. Yeah.
institutions, right?
It definitely makes our world a little more interesting in the valuation space. I mean, and it's only been 9 months, and the person placing there another 3 years made it sound like it's only a short term. That's a long time. So I appreciate the question. Let's move up a couple of slides. Turn that for me, please. Let's talk about scenarios here. Your scenario framework.
Right.
Keep going. One more, I believe. Actually, a couple more. Keep going. And for the viewers out there, Achille is going to go through these slides and many other slides, but I know that we only have a certain amount of time, so I wanted to hit on a couple of things during this particular session. So walk us through this scenario analysis framework here, your base, bull, bear, and stress.
Exactly. So the scenario analysis provides a probabilistic modeling framework that allows valuation professionals to account for multiple potential trade policy outcomes and their impacts on business valuation, on business value. So in this framework, we have 4 main scenarios that are considered. The base case scenario, it has a 40% probability. In this case, tariff remain steady at current levels. So projected impacts, in terms of projected impacts, revenue change, there's a revenue change of -5 to +5%. EBITDA change is considered to be -10 to +10%, and valuation multiple change is considered -15 to +5%. So that is the base case. So here, as I said, tariff remains steady and at current level. Now, in the bull case, tariff has reduced or eliminated, so that's going to lead to a positive outcome. And this is 25% probability that happens. So here, revenue increases between 5 to 15%, right? So where there's no tariff is reduced or completely eliminated. So we foresee a revenue increase by 5 to 15%. EBITDA rises between 15 to 40%. And valuation multiple expands 20 to 35%. All right, so that is excellent. In the bear case scenario or probability, which is 20%, there's a tariff escalation that is, we look at it in terms of percentage that could happen probably in terms of probabilities between 25 to 50% in terms of the rate, in terms of rates increase. So it could be a significant, in terms of value destruction here, because when we are in a tariff escalation, it's very difficult for companies to withstand those headwinds. So revenue declines between 15 to 25%. That's exactly the opposite of the bull case, right? So EBITDA drops 30 to 50%, and multiples contract, valuation multiple contract by 35 to 60%. So it's really a difficult situation for small businesses. And the stress case scenario, this is a 15% probability. This is a case of a trade war escalation, right? Tariff may double to 50%. That leads to severe negative outcomes. And so revenue may drop between 25 to 40%, EBITDA plunges 50 to 80%, and
Absolutely.
valuation multiple compress 60 to 80%. So this approach enables the user, to quantify uncertainty, develop defensible probability weighted valuation estimates, and prepare for a range of possible futures. So that's the idea of scenario analysis.
Oh, that's
And
fantastic. Yeah, this is good. This is a lot of great information, and we just scratched the surface, really. And I really encourage everyone out here listening and viewing this segment today to really sign up for the 4 o'clock, because this is something that we're all dealing with, regardless of the sizes of your companies that you are dealing with, your industries. Tariffs have an impact. Some of them have a positive impact, and then some of them have a negative impact. And I think the way that Achille is going through this will be extremely impactful for you as you go through this particular year and over the next 3 years, perhaps, doing valuation work on small businesses here. And I love the title of it, Risk, Realities, and Best Practices there. Achille, thank you so much for your time here today. This has been an action-packed day, and you definitely added on to this AVW today. Thank you again.
thank you, Stephen. Thank you very
No
much.
problem.
Appreciate
And I'm
it.
going to turn it now over to my very dear good friend, Alina, so that we can move on to the next segment of this show. Thank you, Achille.
Thank you.
Thank you, both of
Before
you.
Alina takes,
Shanda. Yeah.
yeah, before Alina takes over, I just want to go over a few items. As Stephen mentioned, Achille is presenting later on today on the impacts of tariffs on small businesses, on small business valuation, risk, realities, and best practices during the ABW Induct webinar later on today. So if you are interested in registering, there is a QR code on the screen, or in the material, you can click on the register here to take you over to that page. And then also we do have additional upcoming ABW Induct webinars. On November 17th, we had Grabowski on a few months ago, but some technical issues. And so we are redoing that ABW Induct session on November 17th, the Lawyer's Business Valuation Handbook, the 3rd edition. We'll be talking about some information in that. And so for other topics, go ahead and click on that QR code, and it will take you over to the ABW webinar page. And before we move on to the next segment, we do have a number of individuals who, either through instructing or volunteering their time on boards, who we wanted to recognize for this last year. So with our NACB honors, just want to play a quick video highlighting those individuals who helped with the association. And so we'll play that right now.
Are you presenting the video, Shanda?
Is it not working? Hold on.
Okay.
Was that one not working?
No, it's not working, but we can go to the other segment, because I know Michael Mulder is ready, and then maybe you
Okay,
can try
let's go ahead
it
and do that.
after that, if that works for
Okay.
you. And I
Yeah,
know
I'll do it.
there's someone asking about next polling question, but I know Shanda has been dealing with the video and presentation, so polling is on now. So you
It's
have
on
it in
now.
there. And
Okay.
and then now we have Michael Mulder. He is going to do this monthly session about federal and state case law summaries, and he is going to be talking about Pamela Harnack and his marriage dissolution. So you can take it from here,
Yeah.
Michael.
So this is the case we're going to talk about this month. It's called In Re Harnack. It's not actually a divorce decision, but it comes out of a divorce decision. And so when I came across it, I thought it was fascinating, and I thought I'd share it with y'all. It's a case coming out of Illinois. And just as a brief introduction, about 40 years ago, when I told my mother I was going to get engaged, she looked at me and said, "Are you sure? Because marriage is a serious business." And I was pretty sure, and it's worked out so far for the 40 years. But the thing that I've learned from this case is that divorce is an even more serious business. So let's talk about this. This is a case involving Steve Finati. I'm probably mispronouncing his name, but he's not here, so I don't care. And Pamela Harnack. They got married in October 2003. She filed for divorce 5 years later, not quite 5 years later. And the divorce proceeding continued, and at some point, and this case doesn't say where, at what point, but husband stopped participating in the process. And so in March 2010, the trial court entered a default judgment against him. The finding included that he had a net worth of about $7.3 million, including 280,000 shares in the Chicago Board Options Exchange. And those were a marital asset. To put this in perspective, in 2010, when this default was entered, March 2010, those shares would be worth about $8.7 million combined altogether. And in June 2025, when this decision came out, those 280,000 shares of CBOE would have been worth about $64 million. So this is serious assets in dispute. At the time that the original default ruling was being entered, there was a claim being asserted by husband's business partner, who said he was the partner claimed an entitlement to 40,000 shares. So the trial court took the 40,000 shares off of the 280,000 that husband had, and then divided that net amount in half and awarded the wife 120,000 shares, or roughly 50% of the marital estate. Husband finally woke up once the default was entered and moved to vacate the default, which the trial court denied. He then appealed that decision to the Illinois Court of Appeals, and the appellate court denied or affirmed the trial court's decision, pointing out that the husband had completely refused to participate in the divorce proceedings for more than 15 months. He evaded service of process. He refused to comply with deadlines. Basically, I apologize for the pun, but divorcing himself from the process. And so the appellate court said, we're not going to interfere with this. Over the next several years, wife continued to make repeated attempts to enforce the judgment to get her 120,000 shares of stock. Husband continued to obfuscate and hide his assets. He moved money around from account to account, making it difficult to find anything. There was one account that had a sufficient number of shares in it, but since that account was subject to the business partner's claim, the court refused to allow the wife to exercise judgment against that account. This thing keeps going on and on. There was a July 2017 bench trial. The judge in that trial found that the husband had transferred the marital shares, including the 120,000 shares that had been awarded to the wife, into an unidentified account. And the husband was refusing to provide any information on this account. And to the extent there were any remaining shares in the corporate account that everybody knew about, the court's determination was that those shares belonged to the business partner, and therefore the wife couldn't get them. In December of 2019, wife filed an action to enforce the marital dissolution order, which, as you'll recall, had originally been entered in 2010. And in that, the wife's counsel sought either transfer of the actual stock or an equivalent value, which at that point in time was $14 million for her share, not for the total marital value. Husband litigated the enforcement action. Moved to dismiss, that was denied. Moved for summary judgment, that was denied. There was a hearing on the merits of the enforcement action, and the court ordered husband to turn over either 120,000 shares of CBOE or its equivalent value by December 18th, 2020. At that point in time, it was worth about $11 million. Husband appealed those rulings, both the denial of the motion to dismiss and the denial of the summary judgment motion, and the final trial judgment that the court had entered. And all of those, the appeal of all of those orders was affirmed, or all of those orders were affirmed on appeal, and he continued to withhold the stock or cash. During the pendency of the appeal, husband raised for the first time that all of his assets had been transferred to a Belize spendthrift blind trust, meaning he had no knowledge of what the trust actually owned. He didn't know if the CBOE shares still existed in it or if they had been sold, and he had no ability to access those assets because it's a spendthrift trust. I think, and this is reading between the lines, I think nobody actually believed any of that. So he tried to introduce a letter from the Belize trustee. And that letter said that the Belize Trust had never owned 120,000 shares of CBOE stock. And there were a bunch of other disingenuous arguments that the husband was raising. The court ordered, again, based on 10 years of willful and contumacious, I love that word, contumacious refusal to abide by the court order. Again, going back to the original order, the default judgment that was entered in 2010, and ordered the husband to be held in custody for contempt pending a transfer of the stock or payment of $10 million to escrow with the sheriff's office. In short, wife's counsel, because the stock was being valued at various times, decided to stop trying to get current value of the stock and just focus on getting the wife's value. And that's where the 10 million comes from. At some point in this process, the sheriff's office advised the judge that they didn't have the ability to hold shares of stock in escrow. And so the judge then amended the order to eliminate the transfer of the stock and just said, put $10 million into escrow with the sheriff's office. I'm going to have you arrested. Husband appealed that order, claiming that it was impossible since the company had his company had changed its name and the stock no longer existed, and the cash value, if he had it, was inaccessible because it was in this Belize trust. All of this delayed incarceration. The judge's order for civil contempt incarceration, it's actually technically called bodily possession, was affirmed on appeal. And so now we're finally back in a trial court in June of 21, or June of 22, sorry, June 21, 2022. And the husband was arrested on the contempt order and remanded into custody. During his custody proceedings, he filed multiple petitions to be released and for the judge's recusal and for disqualification of wife's counsel. I'm not sure what his base. Part of the problem is, as an appellate ruling, it refers to all the underlying decisions in both the trial court level and the prior appellate rulings. So it's kind of fascinating if you want to go look them up, but I did not. Finally, on April 3rd, 2024, the court denied the petition that predicated this appeal, and he filed an appeal of that order. Appellate court findings. So he argued that his incarceration for contempt is limited to 6 months. And once 6 months is expired, he should be released. And that is because, well, I'll get to why in a minute. His second argument was compliance with the order with the contempt order. No, with the order on which the contempt was based is impossible, as in he didn't have the money anymore, and contemptors should be released because it's impossible to comply with the order. And the court's failure to hold status hearings every 30 days meant he should be released. So, incarceration for contempt conceptually is a coercive maneuver. So in criminal contempt, it is you are being held in contempt as a punishment. In civil contempt, the idea sorry, there's a duplicate of that one. I apologize. Anyway, in civil contempt, the whole idea is that the holding somebody in custody is supposed to provide an incentive for them to comply with the order. And so the language from the appeals court was vital to the administration of justice is the inherent power of courts to compel compliance with their orders. Accordingly, a party may be held in civil contempt for willfully failing to comply with the order. That is the coercive nature. That is we're trying to get you to comply with the order. At some point, it can lose its coercive effect. But it is not sufficient for the contemnor, which is a hard word to say, to force their release by simply saying, you can hold me as long as you want, I won't ever comply with the order, because that would be effectively giving the contemnor the keys to the jail cell. While it is a factor, it is not in and of itself sufficient. And well, there's the line about a defiant witness able to secure his release merely by boldly asserting that he will never comply with the court's order. Impossibility of performance. So his argument was that because all of his assets have been transferred to this Belize trust, that is a blind spendthrift trust, he no longer had any money to give to his ex-wife. The letter that he tried to introduce, though, was hearsay. And for those of you not familiar, hearsay is an out-of-court statement offered for the proof of the matter asserted. So this letter that he was offering was an out-of-court statement, since the Belize trustee wasn't there to actually testify. And it is offered for the proof that he no longer has any of his assets. There is a number of exceptions to the hearsay rule. One of the ones we're most familiar with is what's generally called the business records exception. Except the idea of the business records exception is it has to be a document that has been created and maintained in the ordinary course of business, although business is broadly defined in that sense, because it can be a nonprofit organization, it can be lots of things. But the idea behind the business records exception is that documents created and maintained in the ordinary course of operations are less likely to be false. Since this was not since the letter was not a document created in the ordinary course of the trustee's business, it didn't qualify for the hearsay exception. Oh, good. This is going to work out pretty well. Last thing is his argument that he's required to have 30-day status hearings. And the appellate court said that that was more a guideline than a requirement. Even despite that, the court, over the course of the guy's incarceration, the court had held dozens of hearings, or more than a dozen hearings, on a whole variety of issues. And in any one of those times, husband had and frequently made available or took advantage of these hearings on a variety of topics to introduce the idea that he should be let go. And at each point, he failed to do so. So the takeaways for this, as I said, divorce is a serious business with serious consequences. Ignoring the proceedings can result in costly outcomes, that's the lesson that this guy should have learned in 2010. The lesson he's learning now, and the lesson I think we all should take away from this, is that courts take their orders very seriously. And while it can frequently seem, at least from our perspective, when we're looking for documents and counsel files a motion to compel, and courts dilly-dally on some of this stuff, and they say, well, you don't really need that, you can get away with this, and blah, blah, blah. It gets to a point where they are very serious about it. And when a party is being truly dilatory, the consequences are extremely serious. That's me. The case is in the key value data database. If you have access to it, if you don't have access to it, feel free to reach out. I will send you a copy. And with that.
Thank you, Michael, for that summary of that case. So thank you for your time. For the rest of the people, you have your polling question, the fifth one in front of you. And now we have Austin McNair. He is head of marketing at Hinge. And Austin, he has been with us before, but Austin joined Hinge in 2018 and has been a driving force behind the firm's marketing strategy, helping both Hinge and its clients strengthen their visibility and brand presence with a background that combines strategic marketing planning, project management, and communications leadership. He brings both depth and creativity to every initiative. And today, he is here to talk to us about understanding how to build visibility for your business in 2026. So that's a topic every professional and firm should be thinking about and thinking about right now, right? Because it's almost 2026. So Austin, welcome.
Hey, thanks, Alina. Nice to be with everybody, and happy to be with Ed here as well. How you doing, Ed?
Hi, Austin. Thanks, Alina. So good to be here with you, Austin. It's been my pleasure I've been looking forward to interviewing you. We have, as introduction has already been made, Mr. Austin McNair joining us all the way from Virginia. He's the head of marketing at Hinge, which is a research-based branding and marketing agency for professional services firms like ours. In fact, I have a personal interest in what he has to offer, and we had a personal conversation, not personal, but one that is specific to my situation, our situation. So I'm glad he's here to share it with all the rest of you. I'm sure you can all benefit from what he has to present. So do tell me, Austin, what is the state of marketing today for professional firms? Easy, hard, and let me also say this. We have a generational gap here. When I started back in God knows when, marketing meant you put an ad in the paper or put an ad on, some print publication. Marketing doesn't mean that anymore. So we are still catching up. My generation, the baby boomers, are still catching up. So do tell us about the state of marketing today, and it's changing so fast, I know. So please go ahead.
Yeah. Well, as I said, happy to be here with everyone. NACVA has been longtime partners with Hinge, and when you ask the question, Ed, right, about the state of marketing, where is that at? I'm really happy that I don't have to make up an answer here. I actually have research that we can turn to and kind of explore that answer and explore what kind of trends are happening inside of the financial services industry right now regarding marketing and regarding running your business. And I'm really happy that once again NACVA's partnering with us to help us gather some new data on kind of the state of marketing. Right now we have our high growth study 2026 open. Which is our study, and essentially, Ed, what we're doing is we're studying what are the fastest growing financial services firms doing with their marketing. Because as you mentioned, and even inside of your question there with the generational change, if there's one segment of your business that is changing probably more and more year over year, it's What the heck are we supposed to be doing with our marketing? What should my marketing strategy look like? How much time should I be spending on social media? Should I be running Google business ads? Like, what in the world should I be doing? If you participate in the high growth study survey, we do give away those results completely for free. So I'll put this back on the screen here in a minute, but if you go to hingemarketing.com/NACVA, you can participate in this year's high growth study. And in January, get the results. But answering your question, it's easy and it's hard, right? I think everybody can relate to the fact that we have more tools at our disposal than ever in terms of growing our businesses or doing things that we would quote unquote say classify as marketing. If you talked to me 5 years ago or 7 years ago when I started at Hinge pre-pandemic, digital marketing and just saying that having a business that was investing in digital marketing and content marketing and blogging and writing articles and going out to associations and writing articles for them. These kinds of digital marketing techniques were a little bit newer in the space. But once the pandemic came and everything became digital, the competition exploded. So while we have a lot of tools, Ed, in terms of even now AI tools like LLMs that can help us write content quicker, right? Should we do that? Should we not do that? How should we do it? These are the questions we're grappling with in terms of, accelerating our marketing efforts, but also remaining distinct and differentiated. So right now, it might be easier to be doing more marketing than ever. It's also very competitive and it's harder to be different because now everybody has the same tools.
Yes, and you're obviously on the East Coast, and I'm on the West Coast. So that brings up my next question. Do you, in the old days, you went to a local place that you could drive to or you could get to. Does that matter for people who are listening? Because I imagine most of them are not in your locale. If they wanted to work with you, is locality or is the geography present a situation these days or no?
I think it still matters. I mean, one of the trends that we noticed from this year's research on the fastest growing companies is that fast growing companies are investing in in-person events. Like being physically present has a meaning to it. And one thing I'm really interested in this year is to see if that trend continues. I don't know if anyone on the call can relate to the fact that just with all these digital products in our life and how oversaturated we are in a digital experience, there's something actually refreshing, and a lot of marketers are calling this kind of like a analog revolution, where it's like kind of a nostalgic craving to like get back out there and kind of do business the way that it was done maybe before, in person. And that's not to mention all these, just continue buzzword of the day with AI, all the disruption happening in that space. Can you trust that the person on the other side of the screen is really the person that you want? So I think there's a lot of value that's actually, to your question about proximity and geography. I think there is a lot of value there, and being involved in your local business community and getting out there. I say, especially for a lot of you that are maybe more entrepreneurial, smaller, under $1 million in terms of your business revenue, being out there in your community, your local community, is probably going to be one of the fastest ways to build relationships and continue to grow your business. That's not to say that you should ignore the digital environment, though. And one thing over and over I'm talking to my clients with, Ed, right now is how do we continue to bolster your online reputation? Like I mentioned before, that there was an era here of digital marketing where it was very focused on content and content marketing. And I still widely believe that content marketing has its place. But if you think about what is changing right now with AI search and how people are finding answers to their questions, their LLM chatbot has the answer to a lot of the questions. Now, there might be some questions about the validity of that. And you might, most people would be encouraged to still go speak to an actual expert. But a lot of people are getting, the answers that they look for now, whereas they might have gone and browsed to your website, they might have gone and read your blog or looked for a newsletter or podcast to explore. Now they can have a conversation with an AI bot about it. And so what we need to do as experts is really differentiate ourselves and build up our own reputations. And again, I said in-person events is a great space to do that. But really what we're seeing from the data is that experts are doing this through speaking on video, speaking on webinars, speaking on podcasts, speaking at events. The more you can get out there and speak and bring a unique perspective and really hone in and let people know, like, I know Ed. Ed is the guy that helps expats with their tax services. Ed is the guy that provides this service, this. You can bolster and build that reputation and become known for what you specifically do. That's kind of the marketing task that we have. And as I mentioned, it's quite difficult now just with how competitive the environment is.
Okay. That given, so if I wanted to work with you, I'm in California, you're on the East Coast, does that create an issue, or it's feasible for me to, when I say me, I mean somebody like me who's far away from you to start?
Yeah. I mean, I think, and I think everyone can relate to this as well in the services you all provide, right? We live in a global, like globalized world with, where working remote is kind of the new norm now. But in terms of marketing, right, what I'm saying about the marketing piece that I think would be especially appropriate for folks in the audience is thinking about how am I making those building my business through relationships, and how am I in the marketing process, in your business development process, continuing to drive home those things that make you unique. And of course, when it actually comes to working, remote environments, in-person environments, I think that's all still on the table.
And we're also subject to a lot of other service professional firms marketing ourselves. We're bombarded by, people emailing us, calling us. And the kind of services they provide is so abstract, I cannot even, begin to make sense of it. They always call me when I'm driving or when I'm totally not ready to talk. So they say we do this and that. So my question is, how, like you said, you need to differentiate yourself. You need to make the busy person who's answering your call, or who's, even if you're lucky enough for them to even open your email and read it, to get the message really quick. Is there a differentiating formula for that? Hey, you really need us. This is what we do, and you really need it.
Yeah, Ed, I think to stand out in 2026, right? And the goal here is visibility, right? But talk about when you get in front of people, how do you make yourself memorable, right? For you to be differentiated, we usually think about a few things. We think about, number one, for you as an expert, for you as a valuation expert, whatever your kind of the scope of your work is, what is your unique perspective? And how are you forming that perspective? Is this opinion? Is this research you've conducted? Is it years of experience? Like, being able to weave that into your messaging, talking about how you've come about in terms of developing your unique perspective and personality as a professional. I think that's very, very important today, that we bring more personality with us to work, to the business that we're doing, so people understand who they're working with and they can build a stronger connection. The second is clearly identifying your audience, right? You have a specific audience that you're serving, and that is well established. And when you talk and you give your elevator pitch and you sponsor events, you're not just sponsoring whatever general event is happening in the community tomorrow. You are going to specific places where niche online communities are formed, or, in-person events where, this is a club of people that just do this. You're targeting very niche specific groups because you understand that industry, and you can be a bigger fish in a smaller pond. That is something that we're seeing, especially smaller businesses really thrive in right now, is being able to build into those smaller online community. And then, of course, can you be found? When people go to Google and they actually do search for you, are you going to come up? Are you going to have any Google reviews? Are those Google reviews going to be positive? These are all ththings that I think right now, bolstering that online reputation. Going to your LinkedIn profile. Is it active? Is it up to date? Do you have a significant amount of, followers, connections? Are you a real person? Do you have a real face? These kinds of things just absolutely matter right now.
And
So-
our time is really short. We need to get going. Yeah, it's almost my time, 11:59. Just one quick question. Why should anybody, or when I say anybody, I mean professionals, participate in the upcoming high growth study that you're sponsoring?
Yeah, so everyone on the call right now, we would love to have. We had 88 NACFA members participate last year. We would love to increase that this year. We really value the perspectives of the NACFA community in terms of understanding how you grow your business. And for all that want to participate this year, you just go to hingemarketing.com/NACFA. It takes 15 minutes to complete. And you will get the full edition that we sell at $800, the 2026 High Growth Study Financial Services Edition in January when it releases. And if that wasn't enough, we have a $500 drawing to get a gift right before the holidays going as well for completing the survey. So I hope everyone will take it. I hope that this is a really helpful resource for you and the community. We know that marketing changes all the time, and Hinge really enjoys this partnership with NACFA because we know that these insights can mean a lot to your business. And if you have any questions, I'm easy to find. I'm all over LinkedIn. My email's here on the screen. Feel free to connect with me and contact me.
Well, we're right on time. It's 12 p.m. my time, 3 p.m. Eastern time. So thank you, Austin. It's truly has been a pleasure, not just now, but working with you behind the scenes to get prepared for this interview. You're just a pleasant person to work with. Okay, Alina, back to you. We're done.
Yes, you were great this month with the time. Thank you, Austin. Thank you, Ed.
Of course.
Yes, always lots of information. So we are always running with the time. So thank you, Ed, for that. And to everyone, thank you for joining us. You're invited to attend next month broadcast that is going to be on November 17. So hopefully we'll see you next month. And remember, if you would like to become a guest on the webcast, please email Shanda at shandac1@nacva.com. Thank you, and we will see you next month. Bye-bye.